I'm not a lawyer, but there was an emergency hearing on Monday in Nathan Wade's divorce case. Nathan Wade is the alleged boyfriend of Fulton County DA Fani Willis. And at the hearing, the first motion that the judge addressed was the sealing of Nathan and Jocelyn's divorce documents.
I'm going to grant the motion vacating the consent order, sealing the record.
Then the judge addresses the protective order that Fani Willis filed so that she would not be deposed in these divorce proceedings. So the judge rules that the documents will be unsealed. They were actually unsealed yesterday. First, Fani's attorney made his argument to the judge, and you'll also hear him attempt to bring up the Trump RICO case, but the judge shut it down.
Ms. Willis does not share any accounts with him. DA Willis does not determine what he spends his money on, no matter where it comes from. So in this case, of course, the most recognizable issue is that she's dealing with, over in Fulton County, the election interference case involving former President Trump.
Well, I'll tell you what, Mr. Axum, let me interrupt you. Let me ask you just to focus on the part of the law that says the proposed opponent lacks unique personal knowledge of any matter that's relevant. Are you saying that your client lacks unique personal knowledge that could not be discovered some other way?
I would argue that she does, that the knowledge that she may or may not have, it is not unique. You've got two parties in the case, one who is alleged to have some extramarital affair with Ms. Willis. If that is the case, if that is true, he has that information. We've been at this case, well, I have, but 783 days. And on day 776, somewhere in there, we get this notice of deposition. So to focus on that part of the statute, no. I think there are other means by which that information can be retrieved.
And then Jocelyn'l Wade's attorney made her argument as to why Fani Willis should be deposed. And she also tried to bring up the Trump RICO case, and the judge shut it down.
Your Honor, I think that you honed in on exactly what the issue is here today, naturally. The face of her pleading shows that she has unique knowledge with regards to this case. She asserted in her pleading, her motion for protective order to prevent herself from sitting for a deposition, that she knows the cause of the separation of these people. She knows detailed facts, allegedly, about their relationship, and albeit we'll deal with the falsity of those at a different hearing. That's what she said. She said it in her pleading. I can state as an officer of the court in my place here today that the first time in the 783 days that this case has been pending, the first time that I heard that the alleged cause of the separation was some false claim with regards to my client in 2017 was in her pleading. So I have questions. We don't have to plead adultery in the initial petition, but we also have the ability under OCGA 91115 to amend the pleadings anytime up until the entry of a pretrial order. We have the right, regardless of whether or not the grounds for divorce alleged in the petition is that the marriage is irretrievably broken, to discover information with regards to adultery. We have questions. I want to know about how he's been spending his money. I have a reason to believe he's spending it on another woman. That's my client's money. And I want to ask questions about that. I want to bring one other matter to the court's attention with regards to her position that I think has not been highlighted in this. In her motion, page 9, top of the page, she stated unequivocally, DA Willis stated, that if we pursue this subpoena, we are obstructing justice.
Yeah, you know, Ms. Hastings, that's why I told Mr. Axum to stay away from that, because I don't really want to hear that today.
And then the judge made a decision.
All right. Well, both sides have good points. Ms. Hastings, I agree with. The irretrievably broken does not prohibit you from presenting evidence of adultery if that's relevant to an equitable division of the marital estate or marital assets. However, I also agree with Mr. Axum, and the key part to me is whether the proposed opponent lacks unique personal knowledge or has unique personal knowledge of a matter that's relevant to the subject matter. It seems to me that Mr. Wade would be the first and best source of information on what his income has been and how he's been spending it, and that he would have firsthand knowledge of whether he's engaged in an extramarital affair. Only after I hear what Mr. Wade has to say do I think I can make a determination of whether the proposed opponent has any unique knowledge about these issues. I will issue a stay, and I will stay the deposition until I'm in a better position to make a determination of whether the proposed opponent would have any unique knowledge, unique being the key word there.
So he rules that as of now, he can't rule. He says he's going to wait until after Nathan Wade is deposed, and from there, he'll decide if Fani Willis also needs to be deposed. As a reminder, Fani still has until February 2nd to file a written response to the allegations made by Michael Roman in the Trump RICO case. And then the hearing is set for February 15th for that motion. So we will continue to see how this all plays out.